Thank you, everyone. Please be seated. The case of State versus Gordon is hereby submitted without oral argument. And the same is true for the case of Lowe versus Menard, Inc. Those two cases have been officially submitted. And we will now begin with our first oral argument of the morning, Penny versus City of Winterset and Decker. And it looks like the parties are ready. Mr. Clausen, you may begin.
Thank you, and may it please the court. Counsel, good morning. My name is Zach Clausen. I represent the City of Winterset and Officer Christian Decker in this lawsuit. The Iowa legislature has made a policy determination that the standard of care that applies to law enforcement officers who are operating in emergency response mode is recklessness and not negligence. As this court has indicated, recklessness is a difficult standard to meet in Iowa. In order to uphold the will of the legislature and ensure uniformity in this area of law, the Court of Appeals decision must be reversed as there is no genuine dispute of material fact as to my client Christian Decker's conduct on the date of this accident. This case involves a motor vehicle accident where Officer Christian Decker was responding to an emergency call from an unresponsive person in the parking lot of the Super 8 motel. After receiving the call, Officer Decker is traveling in his squad car with his lights and sirens on, headed toward the Super 8. Traffic is light and it's dark outside. He has a clear view of the intersection. He can see to his right for about a quarter to a half mile as he approaches the intersection. In terms of his speed, he's traveling roughly 30 miles an hour after braking as he reaches the intersection and 25 miles an hour at the time of the impact in this case. Prior to entering the intersection, Officer Decker looks both ways to check traffic. He looks to his left where he sees a vehicle that's far enough away that it's not of any concern. When he looks to his right, he mistakenly believes he sees the light coming from a farmhouse on the opposite side of the roadway, which is the direction that Mr. Penny was traveling from. Mr. Penny, despite stopping for an emergency vehicle who had reached the intersection prior to Officer Decker, proceeds into the intersection where the impact occurs with Mr. Decker.
Now, the plaintiff argues that it's a disputed issue of material fact whether Officer Decker actually looked right or not.
Yes, Your Honor, that is the argument. But if we drill down to what the experts actually say in this case, there's no claim by either of the experts in this case which claims that Officer Decker never checked both ways prior to looking at the intersection. The expert Billington, he discusses Officer Decker's speed and that he fails to react appropriately because he did not see Officer Decker. If we look at the expert Todd Hall, what he says is that there's no evidence that Decker was unable to see Penny in the seconds leading up to the collision. That's different than the argument that he did not look whatsoever. Judge Greer got to the heart of this issue by saying while looking but not seeing might constitute negligence, there is no case law that holds that looking but not seeing without more can constitute recklessness.
Ability issue, and can an expert even talk to whether or not Officer Decker was being truthful when he says he looked or didn't look? Isn't that what this comes down to, whether or not a fact finder would believe him when he said he looked to the right?
So, Your Honor, I mean, there has to be some sort of elevating circumstances or conduct beyond what we have in this case for a finding of recklessness to be had.
Officer Decker didn't. What if he testified, you know what, I was focused, I just went right through the intersection, I didn't even look? Would that be reckless?
So just based on the other conduct that we have in this case, the cases that have considered recklessness consider this sort of from a totality of the circumstances approach, where you're considering a number of factors such as whether there's an emergency response, what the speed is, whether there's traffic congestion and traffic volume as you reach the intersection. Here, there's no dispute that there was an emergency response. Officer Decker was responding to an unresponsive female. This case was pled as a recklessness case. Recklessness is the standard, and there's no dispute that he was operating with his lights and sirens. If we get
His testimony that he did look both ways is unrebutted.
Your Honor. There is nothing, including those experts, who refute that testimony. And if we get down to speed, which I think is one of the important factors here, when we're talking about speed, the evidence shows that he braked for 4 seconds prior to reaching the intersection. At the time that he reached the intersection, he was traveling 30 miles an hour. He was traveling 25 miles an hour at the time of the impact in this case. Now, the plaintiff wants to focus on the fact that he was traveling 60 miles an hour 12 or 13 seconds before he reached the intersection, but that's not the focus here. The focus is what his conduct was at the moment that he reached the intersection and by the time he was entering the intersection at the time the accident occurred.
What I saw, and then the officer testified, other than those two pieces of testimony on behalf of the officer and the city, was there any other evidence to rebut those two experts presented by plaintiff?
There was not. There's testimony from the plaintiff himself, which factors into that, but no, there's not any additional evidence in the record. Getting back to speed.
One question Justice Oxley asked, and I want to make sure I understand your answer. So if the evidence was that he didn't look at all before going through the highway intersection, it's still your claim that that would not be recklessness in considering all the other facts?
Correct, although I think I'd admit that it'd be a closer call, but what we have here is in terms of the speed and visibility of the intersection. I mean, in all of those factors, we're talking about no congestion at the intersection, no traffic at the intersection. If we compare this to even the Bell case where no recklessness was found, in that case, the ambulance driver had an obstructed view of the plaintiff driver by a vehicle that was next to him. Here, we're not dealing with any unobstructed view. There's no hidden vehicles that could have been at this intersection. And the fact that Officer Decker slowed down before he reached the intersection is evidence that he appreciated the risk. This court in Martinez decided that the officer's decision to discontinue pursuit of the suspect when the suspect traveled into the opposite lanes of travel demonstrated an appreciation of the risk rather than a disregard for one. Officer Decker's decision here to slow down before the intersection to 30 miles an hour by hitting the brake for 4 seconds demonstrated an appreciation of the risk that was coming at this intersection in terms of him proceeding past a stop sign, not a disregard for one.
Your reliance on Bell and Fritz, in those cases, they were subject to a traffic control device. Does that water down your reliance at all?
No, Your Honor, I think that in all of these cases, there's going to be different facts in terms of traffic control devices, in terms of congestion and traffic at the intersection. But I don't think it does. I think it's a distinction without a meaningful difference when you examine the officer's conduct. And the officer checked to his right. He did not see Mr. Penny's vehicle traveling down the roadway, but all of the other facts and circumstances are similar to those cases in terms of the officer not having any reason to believe that other vehicles, including Mr. Penny, would be unable to see or hear his approach. I mean, when we talk about him operating with his lights and sirens, there's no indication in the record of any other vehicle that disregarded his lights and sirens. There's no indication that anyone failed to obey or
Line of no indication, the other side of that coin is, in the gray brief, plaintiff said that they had the right-of-way and no reason to believe a speeding vehicle would run the stop sign. There is evidence in the record that there was another emergency vehicle that had gone through. Is there any other evidence that there was an emergency super close by?
Yes, Your Honor. I think if we look at the record, the Super 8 is only a handful of blocks away from where this happened. So the testimony from Officer Decker is that a fellow officer had proceeded through a left turn through that intersection from Highway 92 to North 10th Street before Officer Decker proceeded through the intersection. So what we're dealing with here is a situation where Mr. Penny pulls over and slows for the prior officer, but then he gets back up to speed and does not slow or yield to Officer Decker's vehicle. I think what his testimony is on that is that he was looking forward and looking to the right where that prior officer had traveled to and turned to towards the Super 8 where the call was. That evidence that Officer Decker had saw the other vehicle proceed through the intersection is again evidence that would give him no reason to believe, first of all, that there's traffic at the intersection, and second of all, that any vehicles that might have been near the intersection would not stop for him at the time that he proceeded through the intersection.
North 10th Street.
Your Honor, and 55 miles an hour on Highway 92. So Officer Decker was traveling, I think, 60, but he brakes to 30 miles an hour, and at the time of the impact, he's going the speed limit, which is 25 miles an hour. This would be a much different case, as Judge Greer pointed out, if the record evidence was that Officer Decker had seen Mr. Penny, but then tried to beat him through the intersection, but that's not supported by the speed in this case. In the cases that this court in the past has upheld in terms of a finding of recklessness, most of them are under the Guest statute, but those cases are illustrative for the type of conduct that must be elevated or aggravated beyond ordinary negligence. In those cases, we're talking about driving with knowledge that the brakes are shot. We're talking about going 110 to 115 miles an hour. We're talking about swerving in and out of traffic on the roadway and driving at an excessive speed around vehicles. None of that conduct is present in this case. In terms of Officer Decker's driving, even if we compare it to the Fritz case, there's no complaint that Officer Decker was swerving around vehicles like there was of the officer in the Fritz case. There's no complaint that any vehicles had to drive off of the roadway because they were.
Facts for a moment. This was on a motion for summary judgment, and there are cases out there that say that experts can give rise to an inference of recklessness, and the plaintiffs did have a couple experts that were part of this case. So can you discuss that portion of it? Why should we not just let this go to a jury?
Recklessness is a legal question. This court has indicated that recklessness is a legal question. In Martinez, this court decided on summary judgment that recklessness was a legal question. And again, if we get back to the focus of the actual expert opinions, what those opinions are is nothing more than opinions regarding the officer's negligence. There's nothing in this case in terms of an opinion from any expert that gives rise to recklessness conduct. Again, Judge Greer's quote on this is, while Penny's experts point out potentially negligent actions of Officer Decker, they do not present a factual pattern that resembles reckless behavior as a matter of law. That is exactly what this case boils down to. While there might be negligence, there is nothing to elevate this to recklessness. In terms of his conduct, there's nothing in terms of intoxication. He's not on his cell phone. There's no drug use. There's no evidence that he's looking at the computer in his squad car. There's nothing to elevate this beyond reckless. In all of the cases that this court has considered, none of them could lead to a finding of recklessness on behalf of this officer.
My concern, and then I'll have you address it. So I'm not buying that it would not be reckless to go through an intersection without even looking. I think that would be reckless, in my view. Let's assume that's right. Is there a disputed issue of fact on whether he looked? And my understanding of the record is that the experts indicate that he couldn't have looked because if he had, he would have seen the other driver. So assume that I'm right, that it's reckless not to look before going through an intersection. Is there a disputed issue of fact on whether he looked or not?
Your Honor, the experts say that he did not look good enough or that he did not sufficiently scan the intersection. I mean, Or him looking but not seeing.
Before.
Drivers all the time in accidents. Looking but not seeing might be negligence, but there's nothing that rises to the level of recklessness when you factor in all of the other circumstances in this case that this court has routinely considered in terms of, again, the emergency response, the speed, the traffic, the congestion at the intersection. I mean, here we're dealing with an intersection that's not congested, even like unlike the cases of Bell and Fritz, where there were other vehicles stopped at the intersection.
Or to your position, though, if there's nothing to block his view, and if a jury were to say, I just don't believe him when he said he looked right, why is that not reckless because he wasn't paying attention at all? And he should have been looking left and right, and he just didn't. And he clearly, I think that's what the experts say, is that it was so obvious, it was dark, there were lights on Mr. Penny's car. He couldn't, if he looked, he would have seen him, so he must not have looked.
Your point in that he looked but didn't see just gets to the...
Looked but didn't see, they're saying, for him to say he looked, he had to have seen, so therefore he must not have even looked. That's my point, is can a jury just say, I don't believe him? He says he looked right, but I don't believe him.
So, Your Honor, not based on the evidence in this. And again, beyond that, which I think is merely negligent conduct, it has to there has to be aggravating circumstances giving rise to recklessness beyond the fact that he did not see him. Thank you.
Dickey?
Madam Chief Justice, and it may it please this court, my name is Gary Dickey of Dickey, Campbell, and Sahag Law Firm in Des Moines. I represent James Penny, who asked this court to reverse the district court's grant of summary judgment and affirm the Court of Appeals decision. In Morris versus Leaf in 1995, on page 391 of the decision, this court set forth 3 factors in determining whether or not a person acts recklessly under 321.231. First, there must be evidence of an intentional act done in an unreasonable manner. Second, the individual acted in disregard of a risk so obvious they would have known it. And third, the risk was so great as to make it highly probable that the harm would follow. At the summary judgment stage, the question then is whether or not the plaintiff has put forth sufficient evidence to create a genuine issue of material fact on all 3 of these elements. And of course, we're also given the added deference, as noted on page 19 of our brief, that courts generally view questions of recklessness as fact-intensive jury questions. Taking each of these elements, what the district court should have done was put a ledger to the left of the defense facts and a ledger to the right of the plaintiff's facts, and determine whether or not the defendant has shown the absence of a genuine fact in the initial motion, and then viewed the plaintiff's facts in the light most favorable to them on all of these elements. That's not
Cases that actually come out with recklessness rather than trying to distinguish the cases that don't find recklessness?
Short answer is no. What we do have is in the Bell decision, this court looked to the New York Supreme Court's case in Green, where they found a genuine issue of material fact, and noted in the Green decision, a really important fact was that the plaintiff driver had the right-of-way and the emergency driver did not.
About that, let's assume your client did see the cop. Doesn't that right away switch to him at that moment in an emergency?
That goes to a question of comparative fault. I don't think we
As you've been arguing that you've been riding this horse quite a bit in your briefs and today, that he had the right of way. But if he had seen the officer, that would not be true in an emergency setting, correct?
I don't think that's clear. I don't know that issue's been raised. I don't think it was decided. And
Making it important. And I'm thinking, I think it's pretty clear that neither one, according to their own statements, saw the other. That seems to be the point.
subsection 231 allows an emergency vehicle to go through a controlled intersection with their lights on. I don't think it switches the right-of-way. In any event, the driver still has to act in a reasonable manner with due regard to the safety of others.
It's the driver's obligation to pull over, right?
To yield, correct, yes, yeah.
Right away. All right, so here's what bothers me, yeah, Mr. Dickey. I mean, you recited the elements accurately in my view, and you know, it's sort of this intentionally doing an act in disregard of a known risk of great magnitude. That would seem to fit perfectly a situation where if we went back and looked at the records, you know, Officer Decker just went right through the intersection, didn't slow down. The one fact that is not in dispute here is he did slow down significantly prior to entering the intersection. And the only reason he would have slowed down was to look. I mean, that's there's no other logical inference than that. He may have not looked far enough. He may not have looked quickly. You know, he may have looked too quickly. But that's the state of the record. Doesn't that establish that he wasn't reckless?
No, it doesn't. So let's just be clear what the record does show. At the time he enters the intersection, he's going 30 miles an hour. Right before impact, he accelerates. That's shown both in the graph as well as his testimony on pages 41 and 42. So he's accelerating through the intersection, not slowing down. He's certainly not braking. So
help me with that one. I don't understand. If he enters the intersection going 30, and at impact he's going 25, how could he have accelerated through? I mean, that number's going down.
that would suggest, although we're speculating, this isn't in the record, that when he hit, it slowed him down and he turned before he came to a stop. I mean, if you look at the chart, he actually accelerates from 30 to 25, which is inconsistent with how acceleration works. But his testimony is, I don't think there's any dispute he was coasting. He was not braking into the intersection, and his testimony was that he was accelerating through the intersection. And so if you compare that to his testimony of how he approaches another intersection in the city where it's more of a blind intersection, and he admits he comes to almost a complete stop. So getting back.
The fact that he wasn't accelerating through in a way at least that indicates that the numbers are going up. In other words, that he's going from 30 to 40, right, or 30 to 50, suggests that he wasn't trying to beat a car through, right? He didn't sort of see it and put the pedal down.
That he was not trying to beat Mr. Penny through.
Sort of support this notion that he just didn't see it at all?
One of two things, our expert has testified that one of two things are possible. Either one, he didn't look, or he didn't afford himself enough time under the circumstances to be able to see. And that's specifically what the Court of Appeals recognized, that there was a genuine issue, a material fact as to whether Decker sufficiently scanned the intersection before proceeding through the stop sign. I mean, that's the correct analysis there in terms of the factual dispute. And
A little bit. So I asked Mr. Clausen, is the dispute here about whether he afforded himself sufficient time to look, which would seem to indicate negligence, or whether he looked at all, which in my view would indicate recklessness? And as I read the expert report, the first expert says he did not afford himself, Decker, the time necessary to properly discern whether the lights were in a building or a car. And then the other expert says there is no evidence to indicate that Officer Decker was unable to see Judd Penny in the several seconds leading up to the collision. I'm not sure either of those say he didn't look. So what are we disputing, whether he looked or whether he looked sufficiently long?
so I think both are reckless, but if I'm wrong and we have to show he didn't look, I think circumstantially you can infer that. I mean, suppose he said he ran a mile a minute. No expert would say he didn't because the expert wasn't there. They don't have personal knowledge. What they can say is from the circumstances, we know that a human being cannot possibly run at a speed to have allowed you to run a mile in 1 minute. So the circumstances would suggest either that person's not being truthful or the stopwatch was not working correctly. You haven't seen Justin. But the point is, we cannot prove a negative. What we can do through expert testimony is eliminate reasonable explanations as to what did not happen, which was that he afforded himself enough time.
Penny had the right-of-way and no reason to believe a speeding vehicle would run the stop sign. I have a problem with that. No reason is pretty hard of a position to take. If I see an ambulance, a fire truck, no matter what it is, it may stop my phone call. It may make me turn off my radio. All of a sudden, I am a different driver when I see something. And so it should come as no surprise that there might be another one. So why is that, when you say no reason, I think that's an unfair statement. Your client certainly was on notice to the point he pulled over. And I think the exhibit was even marked to show where he pulled over to stop and right before the intersection. So help me understand, why isn't it reasonable for the officer to then believe he saw that ambulance too, or I think it was an ambulance number one, whatever the emergency number one vehicle was, he saw it too. Why isn't it reasonable for him to assume other people have seen this guy and I'm coming next?
I was trying to make was to draw a contrast with the Fritz decision, where the driver actually made contact with the plaintiff driver. The emergency driver made contact with the plaintiff driver and assumed that that driver was going to yield. The plaintiff driver did not see the emergency vehicle because they were blocked by traffic. I mean, that's not the situation that we have here. He didn't see him because he either didn't afford himself enough time or he didn't look, and that's a jury question. And I understand that perhaps Mr. Penny
Just for a second, you said that that's a jury question. What evidence would the jury be able to rely on to conclude that Officer Decker did not look at all?
Because the expert's testimony is that from the vantage point coming, and this was Mr. Penny's testimony in his deposition, it's from the vantage point, he would have had an eagle-eye view to easily see Mr. Penny. Mr. Penny had his lights on and was coming, and so there's no explanation as to why he would not have been able to.
Was, I looked, I saw a light, I thought it was a farmhouse.
Agrees, we lose. But if the jury agrees with us that that's not a that's not a believable statement, then we win.
Justice McDonald's question, if not looking at all might be reckless, but looking and not seeing is negligence, what evidence would the jury be able to rely on to make that distinction? To say, other than just flat out believing that disbelieving his testimony. Is that the only thing that you have, and what case then would support getting past summary judgment based on simply on not believing what evidence is presented?
So the circumstantial evidence is that Mr. Penny had his lights on, he was driving, he was, quote, fully available to be seen by Officer Decker. That's on page 112. That Officer Decker had 14 years of training and experience and would have known of the dangers of going through an intersection without a stop sign, that Decker had enough time to stop because Penny would have been able to be seen. The cause of the collision was, quote, the intentional disregard for the safety of the general motoring public, unquote. Page 113, Officer Decker demonstrated, quote, a clear lack of regard for the safety of others, unquote. I mean, I think those circumstantially and those expert opinions create a genuine issue of material fact. I think the Court of Appeals was spot on in its analysis. Viewing this evidence in the light most favorable to Penny, a reasonable juror could find that Penny was visible to Decker and Decker did not sufficiently scan the intersection, if at all, before accelerating through the stop sign. That's on page 13 of the Court of Appeals decision. And so I'll go back to the elements. The first element is an intentional act done unreasonably. I don't think there's any question all of his acts were intentional. His acceleration at the intersection, going through the intersection, and I don't think there's any question it was unreasonable.
Not seeing intentional?
Scanning but not seeing intentional. Again, if the record shows that he scanned and did not see, it's because he didn't afford himself enough time to do that. And if that's not reckless, then that's what this court's decision is. But That's what the Court of Appeals concluded, I think correctly, that under these circumstances, very fact-specific circumstances, there's a genuine issue of material fact. I don't think he has to intend the result. I don't think that's what the standard is, but were his acts intentional, were they unreasonable? And of course they were unreasonable. Judge Greer, she didn't say very unreasonable, but she essentially said they were very unreasonable in the way he acted. So the first element is satisfied.
Intentionally do an act in disregard for a known risk of great magnitude. And the reason we have this statute is we want to motivate the officer to get to this unresponsive person as quickly as possible. So the officer isn't going to take the normal precautions they would take. And we accept that. It's just if they intentionally do an act in disregard of a known risk of great magnitude, then they've crossed the line. And I have trouble seeing that if, in fact, that he slowed down before entering the intersection. He at least attempted to see if the intersection was clear and just did a poor job of that.
I would ask this court to compare how he went through this intersection with how he goes through the other intersections in town, which he testified in his deposition, where he comes to a near complete stop. I would ask this court to compare his actions versus those in Bell and in Fritz. In Bell, it wasn't a controlled intersection from the emergency driver, their direction.
For the officer to get to have, it's reasonable for him, and this was in your, or in the motion for summary judgment, undisputed facts, and it makes reference to the deposition of your client. As he entered the intersection, he was looking to his right at the emergency vehicle that had been approaching him from the west. Isn't it reasonable for the officer to assume that somebody who is approaching an intersection and he just saw law enforcement should probably be looking all the way around and not just rubbernecking to the right? Isn't that reasonable for him?
That's not what the experts say. This wasn't a situation where he saw Mr. Penny and concluded that Mr. Penny saw him. He just didn't see Mr. Penny, either because he didn't look or he didn't afford himself enough time. Thank you.
Mr. Clausen.
Thank you, Your Honor. May it please the court. Justice Christensen, I believe you got to the heart of this issue when examining the Iowa case law on this issue. There's no Iowa case in terms of police responses which could give rise to a claim of recklessness based on the facts in this case. If we look at the decisions that the Court of Appeals and the majority actually relied on, 2 of them or 3 of them are out-of-state cases. Judge Greer goes through why these cases are distinguishable to this case. She indicates that that's because there's a congested intersection, which we're not dealing with here. But if you actually examine these cases, and this is pointed out in our briefing, the question in those cases is whether the officers slowed down at all. Not whether the officer slowed down sufficiently, it's whether the officer slowed down at all. Here we know that it is undisputed that the officer slowed down leading up to the intersection.
Mr. Dickey, but the record makes reference, it's either a deposition or the testimony motion for summary judgment, I'm not sure which one, of a video that clearly shows Mr. Penny. There's no video for us to see, though, is that correct?
I don't have an answer for you today why that video was not included by either party in the summary judgment stage, but what I would say is that we have all of the evidence surrounding the collision in terms of the speed data, in terms of the statements from the witnesses. And getting back to the cases that the Court of Appeals decided, one of them was the Puth case from 1933, which is again a guest statute case. But in that case, the driver was swerving from side to side. He was intentionally speeding. He was an inexperienced driver, and he wasn't slackening his speed as he's going down a hill. Here we have evidence again that there's no swerving like there was even in the Fritz case. The officer is slowing down as he reaches the intersection, demonstrating an appreciation of the risk rather than a disregard for the risk. The plaintiff wanted to focus on a persistent course of conduct here that they believe can drive the day and lead to a finding of recklessness. Again, the only fact here or factor here we have in terms of negligence or recklessness, is that the officer looked but did not see. There is nothing beyond that. There's nothing.
Pushing back on that a bit, there's, I think, a way to view this, that the police officer came into this intersection perhaps thinking, I maybe don't have to look. I'm going to slow down enough so that everyone sees me, and kind of coast through it. Isn't that possible that a jury could think that, right? That the slowdown wasn't really for the officer to start looking, but just to slow down so that people see the officer coming through with lights flashing.
I don't think that we can entirely disregard his testimony about looking and seeing and why he slowed down. He was traveling at 60 miles an hour before the intersection. He slowed down because of the intersection. And I think part of this gets back to Justice Christensen's questions about neither party being able to see one another and the statute. We have evidence here that the plaintiff saw the prior emergency responder. There is certainly an obligation to yield in the Iowa Code to emergency vehicles. And when this officer approaches, he sees a prior emergency vehicle go through. He indicates that he scans the intersection and simply looks but does not see. Because he made a mistake, that does not give rise to a claim of recklessness.
Go ahead. Okay. Is this a case where every second counts in this kind of emergency where you have an unresponsive citizen?
I think that's why the legislature has provided these exemptions to law enforcement. If we look at what the Morris case says, it says assuring police protection free from the chilling effect of liability for split-second decisions. It is an important policy justification for curtailing liability. That is why the legislature made the decision that recklessness is the standard and not negligence. That is why the officer's conduct has to rise beyond ordinary negligence and rise beyond looking but not seeing.
Just so I get in during your time, I wanted to ask you, what about Justice McDermott's hypothetical? I don't know if you really addressed whether or not that would be recklessness. If in fact the officer had slowed down, and let's just assume he did not look. He assumed that others would see him. Does that rise to conscious disregard or indifference for safety?
That's pretty close to what Justice McDonald was getting at earlier. I don't think so when you compare it to the totality of the circumstances, but it would be a closer call than what we're dealing with here in terms of having the evidence that the officer did scan both directions and slowed down as he approached the intersection. Thank you.
Versus City of Winterset and Decker is hereby submitted. And we'll have just a brief pause while the parties prepare for the next case, Tweeten Farms versus Tweeten.